Hey, Danny Gittings. Danny, good morning to you.
Good morning.
We're going to be talking today about the judicial review on oath-taking and disqualifying legislators and the possibility of an interpretation by the NPCSC that would override that review. The Court of First Instance yesterday heard arguments from the Chief Executive and the Secretary for Justice saying that the LegCo President failed to observe the Oaths and Declarations Ordinance, while counsel for the President said that it was a matter for him to decide. The government said it hasn't asked for an interpretation and hadn't received an answer to inquiries about whether there would be one, as has been widely reported by the media. So what's up? Email us with your thoughts, questions, comments. Our address backchat@rthk.hk. Our Facebook page is Backchat on RTHK Radio 3. You can call us 233-88266. After 9:20, we're talking about recycling Note 7, what to do with those 4 million odd Samsung phones. Joining us for our first discussion, we have with us now Lawrence Ma, barrister, chairman of the China-Australia Legal Exchange Foundation, NPC delegate Peter Wong, and Mark Daly, an international human rights lawyer.
Lawrence Ma, good morning. Let's go to
Good
you
morning,
first.
Danny and Hugh.
What did you make of these some of the statements by counsel yesterday during the court case? The government lawyer saying that they'd written to the central government, but they just didn't know whether an interpretation was forthcoming, and then she pushing the judge to deliver a ruling as quickly as possible.
Yes, I have thought that the government has been informed by the NPC SCS to the process of their meetings, because as you can see from the reports from the media, it seems that this interpretation of the basic law hasn't been put on agendas. It seems that there is a final item to the table of agenda, which they might on Monday vote on to this additional topic, if it is an additional topic for the meeting.
Well, what would you say that the chances of interpretation are then? I mean, we haven't seen anything definite, have we? We've seen a lot of speculation.
No, but I would have thought that we Hong Kong people would have to see, from the view of the central government, their real concern with respect to the unpredictability of the outcome of the litigation in Hong Kong. If I may fit in 3 points. First, the Section 21 of the Oath and Declaration Ordinance only applies to disqualify if the person declines or neglects to take the oath. Now, technically speaking, both of them didn't decline to take the oath because they didn't refuse to go into chambers to take the oath. They didn't neglect to take the oath because they did not forgot to go into chambers. So taking or making an improper oath technically probably wouldn't disqualify them. Now, that's one of the uncertainties for the Hong Kong litigation. Second, there's something called the margin of appreciation, or the principle of judicial deference. Whereas, because under the known principle of separation of powers, as recognized by the courts in Hong Kong, the judiciary would not want to step into the legislative territory if the legislature has not done things unconstitutional. So the court may decline exercising jurisdiction, and which is one of the major points which the lawyers for the President of Legislative Council, as well as the two Legislative Council-elect, was arguing. The third point is the court certainly, even if the court rules against the declaring the invalidity of the vote of the oath takings by the two of them, the court will not issue an injunction restraining the Legislative Council President from allowing a second swearing in. It is simply too much for the court to step into the territory of the Legislative Council. So that if the ball is back, roll back to the Legislative President, Legislative Council President's court, then a retaking is very likely. Now, based on these 3 points, I can understand that there's a real concern by the central government that the unpredictability of outcome of the litigation may eventually result in them being given a second chance, which is, in the eye of the central government, probably intolerable.
Can't it go back to the President, and then the President says, it's my decision, and my decision is they can't retake it?
Well, that's the risk the central government has to take.
So you're saying you understand why these stories about an possible interpretation have come up, because basically the government's got a weak case. and the central
I think the
government
government has a strong case in our view.
You just pointed out several deficiencies in it.
You were quite a good advocate for the other side.
In fact, yes, you could have appeared as a counsel for Yao Wei-ching, couldn't you? Those arguments you put forward.
But it is. I thought it would be difficult to convince the central government that it is a risk-free or a guarantee that they will win. The government will win. I mean, you can't give a guarantee, of course. So, I mean, facing with that sort of report, probably from the Hong Kong government, well, the central government has to make a decision whether they want to take the risk or not.
But a interpretation by a standing committee is not a risk-free option either. I mean, you'll see. I mean, be interesting to hear your own opinions on it. Many members, even of the pro-establishment camp, saying that this was absolutely the wrong thing to do at this stage.
We can't predict what the interpretation would be, but it seems that people have been saying that the oath-taking under Article 104 can only be done once. Of course, I mean that would be pretty much so determinative on the qualification of the two. But if it is not risk-free, because it still has to come back to the Hong Kong courts here to adopt that interpretation and apply the interpretation to interpret the law.
But you're saying that this interpretation would fly in the face of quite a clear law. You're saying that the interpretation would overturn what seems to be, in your mind, a fairly open and shut case.
Well, I thought that the court facing with that judgment would have to implement it. That interpretation would have to implement it, and the two would be disqualified. That's for sure. But as to the case, as to whether there is another Mr. Wong Ting Guang who has been given the second chance to swear, that may affect his position too.
Do you support or oppose the Standing Committee issuing an interpretation at this juncture? Yes or no, Lawrence Ma?
Well, I would still prefer to take the risk and to have the matter determined in Hong Kong.
So you prefer not to? You prefer not to have an interpretation?
Yeah. Well, I would still prefer to, because I can see that the government do have a strong case.
Okay.
In the common law system, yes.
Also with us is NPC Delegate Peter Wong. Mr. Wong, good morning to you.
Good morning.
Hi, thanks for joining us once again. So, is there going to be an interpretation?
That, I think at this stage, we haven't heard anything about that, but the thing is certainly the central government, under the NPC authority and the basic law, they have the ultimate say on the interpretation of what goes on in this oath-taking in the legislature. But I think so far I've heard Mr. Ma talking about really the technicality of the debate among the lawyers in yesterday's. People have expressed different views on that, but I think the whole substance of the oath taking by the two young people, what they have said, what they have acted, is really very, very annoying to the Hong Kong general public, and not only just Hong Kong, I think to the Chinese people at large, worldwide. So it's really caused a rush. All right. In Hong Kong, we have our own legislations, and we certainly have our very solid legal framework. But the SAR's legal framework is really to protect the constitutional status of Hong Kong. Now, what they have did, these two young people, is really way beyond that. They are challenging the constitutional status of Hong Kong. So I think that the Standing Committee, the central government, certainly is very concerned with it. But so far at this stage, I also believe that it's better to be really handled by let us the Hong Kong procedures under the basic law. It is desirable for the Hong Kong's legal proceedings goes through first. If the outcomes is not really to the satisfaction of the overall people's sentiment here, and then people feel strongly about this, and I think that would be the time to consider whether an interpretation is required. So I hear a lot of see a lot of publications about that. Well, it's immediately or imminently the NPC would make some form of a declaration. I think I haven't heard about that yet.
You haven't heard about it, so, but where are all these stories coming from? I mean, there must be something going on.
Well, in Hong Kong, there's so many things goes on the newspaper. I mean, if you hear them all, that is really the problem that we have. But the thing is, we go back to the content of the context of the issue is that the two young the people is really doing something very seriously wrong and hurts. I mean, the feeling, the compassion of all the Chinese competitors, and also even in the sense of the institution of a legislature making an oath with actually a negative attitude, and it has been displayed. I mean, all over in the media. So it's really antagonizing people.
So let's get this clear. The National People's Congress Standing Committee certainly has the power to issue an interpretation, but you don't feel this is the right moment to do so?
Yes, this is not the appropriate moment, yeah.
And how about after the court delivers its judgment early next? Well, of course, by then their meeting will have finished, but after the court has delivered its judgment, would that be the right moment, or should you wait until a case goes up through the higher courts, which could take years?
Well, I think if there are some procedures that we would, I think then it was if the court make a judgment, the Hong Kong community at large is not happy with. I think that it would be reflected in the sentiment in Hong Kong, and I think taking that number one in the Hong Kong community, and secondly, from the constitutional rights point of view, the Standing Committee would certainly assess that and to make their judgment. Whether they should step in or to allow the case to go further and take a longer time, I think that is a matter for the Standing Committee to consider.
Would it have retrospective effect? Would it apply to this case if there was an interpretation?
If there was an interpretation, I think that if an interpretation is made prior to at least even the first court hearing in Hong Kong has not completed, I think that it may not be desirable. But I think that from the
judgment
point of view, under the basic law, they have the right.
Maybe I'll answer that one. I mean, the basic law quite clearly says that interpretations issued by the Standing Committee, judgments previously rendered shall not be affected. Now, there's some argument about what that phrase means, but in the past that has always meant that when a Standing Committee interpretation was issued, it did not affect court judgments that have already been delivered before that date. And this point was being made by Regina Ip, actually, when she was suggesting you should have an interpretation.
So it wouldn't have retrospective effects.
Well, you can argue about what that means, judgments previously, and there was a court case on that as well, but it would appear that it shouldn't have an effect on judgment already delivered.
Peter Wong, what harm could an interpretation do?
What harm? I think it's really just a procedural. If, say, for example, the Standing Committee feels so strongly that they want to make a explanation prior to the completion of the procedures in Hong Kong, that means they feel it so strongly that this act of promoting Hong Kong independence and then also relating the Hong Kong independence movement with Taiwan, with the rest of the world, I think that would really be, China would look upon this as really a security matter,
sure.
On the national level.
You express kind of reluctance. So I'm just saying, what is the harm that could be done? What do you see as the downside of an interpretation?
Well, I'm not assessing that because, as I said, that it has got to, before we come to assess whether there's a downside or upside, we've got to see the reactions of the Hong Kong community at large. If the court technically just may make a judgment that is against the view of the Hong Kong people at large. But I think you do have an upcry in Hong Kong to start.
Well, you've got different views. I mean, this is HongOng. Some people say one thing, other people say another thing.
Well, but I think in this case, this is very clear.
It's very clear that tens of thousands of people. It's very clear that tens of thousands of people
are doing, and then there are examples which they are setting.
Yeah, okay, but it's very clear that tens of thousands of people voted for these legislators.
Well, that is before they make this vote. And before their acts in the oath-taking provocations,
Peter Wong, you said you don't think it's a good idea for the Standing Committee to issue interpretation at the moment, but should they stay silent, or would it be appropriate for them perhaps to issue some kind of warning or statement of concern instead of an interpretation?
Not a sort of a warning. I think that at this juncture of time, I mean, we have got to come up, because Hong Kong is an SAR of China, and China is having also an international portfolio, and now that we do have some international controversies, it's really basically China, America's international relations, especially in the South China Sea. Surrounding us, Taiwan, Philippines, Vietnam, there's a lot of issues goes on. And Hong Kong is just a chess on the whole board. Now, the message of Hong Kong independence is actually inflicted on the national security, national policies. Now, I think that if NPC instead of making a judgment, would make some comments on that, I think that is also reasonable.
But Peter, you also understand that a ruling on this does not make that pro-independence sentiment disappear. It may have the opposite effect.
Well, it carries on, but the thing is that people have got to make it clear that where they stand. Now, whatever people like it or dislike it, this time we are really talking of the constitutional status. You believe that Hong Kong is really a rightful sovereignty of China or not? This is the question. It's not. It's what. Yes, we have a respectable legal system, but that legal system is to protect the constitutional sovereign right. If that is being affected, I think that the central government certainly would look upon this seriously.
Yeah, Mark Daly is with us, a human rights lawyer. Good morning to you, Mr. Daly.
Good morning.
Thanks for joining us. Yeah, isn't that argument strong that the MPC Standing Committee should intervene because this very much concerns relations between Hong Kong and the mainland of China? This is a matter of sovereignty. That's the whole heart of this argument, and therefore it's very appropriate that the Standing Committee play their part.
Well, no, I agree with the sentiments in the Barr statement, and I think the murkiness and the lack of transparency over whether there even will be an interpretation or not is already dangerous for the Hong Kong legal system. The threat hanging over the legal system is dangerous for the legal system here. Even talking about saying, "Oh well, we don't think they should interpret at this stage," is dangerous. They shouldn't at any stage. We have the wherewithal here in Hong Kong to deal with this. The legal system, look at the caliber of people arguing the case. We've got the legal system and the political system here that will deal with it.
But this is not exactly new, Mark Daly, is it?
Independence is a sensitive issue, no doubt. It's a sensitive issue, but we've got the legal system here to deal with it. And I agree with the Barr statement that any benefit gained from expedient interpretations are far outweighed by the basically the erosion of confidence in Hong Kong's legal system. Talking about independence is different from affecting independence. So I disagree with the with certainly the oath takers the way they did that, the two of them. Let them feel the result of the political consequences of what they've done. A little bit childish. Instead of gaining votes, they will lose votes over this.
Well, if you want to test out the political consequences, you should.
If they got in and argued for independence, we know from the basic law to amend the basic law for Hong Kong to be independent is fanciful, but to speak about it, Hong Kong has freedom of speech. So in a non-violent way, speaking about it is not a problem. And if they interpret, I think one of the hosts said, yes, this could help get more people wanting independence. This is precisely why young people want to be independent. They look at the system across the border and they say they don't want that system.
Mark Daly, you're saying let them feel the political consequences, but surely the way to feel the political consequences is to go before the voters again. If they're disqualified and you have to have a by-election, that really will be, that will be a test.
And that may be one of the outcomes of this. But let the Hong Kong legal political system deal with it. Interpretations are bad. Okay, they are anti-rule of law.
But they're part of they're part of the basic law, aren't they? Interpretations. We may not like them.
They are not. No, they're not. They're not.
You're saying the Standing Committee doesn't have the power to...
The Standing Committee has residual power to make interpretations. That's not supposed to be used. In extreme circumstances, that power is there. We acknowledge that power is there. But for there to be one country, two systems, that power cannot be used willy-nilly, and this is not a situation to use it.
Lawrence Ma, do you want to come back on that point?
Oh, yeah, well, I think the NPC's power to interpret is a substantive power instead of a residual power. That statement may not be right. And in the Court of Final Appeal case of Lau Kong Yung, the CFA has already confirmed that the power of interpretation of this NPCSC is general and unqualified.
Yeah, and to some extent, Mark Daly, it seems you're refighting battles from sort of 15 years ago. I mean, it was accepted, as Lawrence Ma just said 15 years ago, that the Standing Committee has the legal power basically to do what it likes as far as the basic law is concerned.
Yeah, no, I agree. No, it's a residual power, but it shouldn't be used. They have to have restraint. They have to have restraint on it. Of course, they can do whatever they want. But at the end of one country, two system, if it becomes the normal course that you override Hong Kong's legal system, if there's no restraint on that, there's no more one country, two systems.
Would it really do so much damage? And we've had Standing Committee interpretations before. Every time we had...
Already doing damage. When legal teams have to consider certain arguments, whether they're going to make things or not, whether this will prompt an interpretation or not, it's already doing damage. Already eroding confidence in the legal system. How can you, when you've got the specter hanging over your head that there's going to be an interpretation?
Well, we had all these kind of...
Who's going to trust the courts?
People do still trust the courts. It's now being... it's getting on, 17 years since the first Standing Committee interpretation. That reversed a court judgment, and there were all kinds of apocalyptic forecasts after that Standing Committee interpretation. But people do still trust the courts in Hong Kong 17 years later, notwithstanding Standing Committee interpretations. Mark Daly?
Well, this...
You're in and out all the time.
These type of interpretations will continue to erode confidence in the courts. It's going to be a march, I think, on Monday again.
Well,
by lawyers.
There's going to be a march. What happens if there's no interpretation?
What's that?
What happens? You go marching and there's no interpretation.
Well, I understand there's going to be a march. So, again, people are very, very concerned about this.
Okay, Peter Wong, did you want to come back?
Yes, I was just saying that when Mark continuously saying that there's an erosion of confidence in Hong Kong, but I would say the otherwise. I mean, the fact that a true Chinese sovereign state status of Hong Kong, instead of eroding, but really enhance, the status and confidence of Hong Kong. I mean, there is one school of thought. But I think one thing I'd like to put forward is that the Standing Committee's interpretation, that ruling is actually is part of the basic law, which is part of the Hong Kong legal standing as well. I mean, if there are foreign friends who do not understand that, I think they should learn and accept it earlier, the better. I mean, the Hong Kong is ruled under the basic law. We do have a lot of arenas. We respect the practice of the common law in the past, but at the same time, as it enters into the SAR of China, there is the basic law, it governs it, and the interpretation of the Standing Committee is part of that, part of the legal system.
Okay,
it's not that they can do it in their own free will. There's also a procedure.
Okay, we've got a break for the news at 9. We will carry on in just a few minutes' time. We want to hear from you as well. Backchat@rthk.hk is our email address. We've got quite a few emails and comments on our Facebook page to get through, and some interesting questions raised there as well. Keep them coming. The weather before the news now, it's going to be fine and dry. Maximum temperature about 26 degrees. The outlook mainly fine today, with temperatures rising progressively in the next couple of days, and then it's going to be appreciably cooler in the middle of next week. 20 degrees at the moment, humidity 69%.
But the overall sense in Europe is likely to be concern at the threat of delay and curiosity as to what will happen next.
The pound rose after the court's decision. You're listening to the news on RTHK.
Welcome back. This is Backchat on a Friday morning discussion programme with Danny Gittings as your co-host. My name's Hugh Chiverton. We're continuing to talk about the meeting yesterday, the judicial review, which was heard yesterday, and the possibility of an interpretation by the NPC Standing Committee, which may or may not happen. We may know a little bit more next Monday. We have with us, talking about the ins and outs, NPC Delegate Peter Wong, Lawrence Ma, who's a barrister, chairman of the China-Australia Legal Exchange Foundation, and we're also joined now by Richard Yip, who's another barrister and member of the Progressive Lawyers Group. Our email address is backchat@rthk.hk. This is a programme where we want to hear from you. You can always call us as well, 233-88266, if you want to join the discussion. You can go to our Facebook page as well. That's Backchat on RTHK Radio 3. Later, we're going to be talking about the question of what to do with all those Samsung Galaxy Note 7s. After 100 cases of exploding phones around the world, it's reported that Samsung is considering dumping nearly 4.5 million of them. Some people have different ideas about what to do with them. We'll be talking about that later in the programme. In the meantime, once again, our email address backchat@rthk.hk.
Or on our Facebook page, Backchat on RTHK Radio 3, a couple of comments coming in there. Henry says, irrespective of the outcome of the judicial review, the National People's Congress Standing Committee is very likely to interpret the Basic Law to the effect that Leung and Yao will lose their seats. The Global Times editorial mentioned that the will of 1.3 billion Chinese is that these two have to be unseated, and this will materialise. The CCP newspaper echoed the same, and the hard word struggle is repeatedly used. Given this rhetoric, one can sense the possible outcome. C.Y. Leung's steadfastness here is critical and consistent with his character. Leung's assistants include those who participated in the Mongkok riots. I'm surprised he has so many assistants, or should we call them professional rascals? Thank you very much, Henry. In a different vein, TC says, in theory, judicial independence should mean that a threat of the Standing Committee interpreting the Basic Law should have no effect on how Hong Kong courts operate. But rumours of an interpretation during the upcoming Standing Committee meeting are clearly a move to threaten the court. Several issues are deeply disturbing with these developments, the worst of them being restricting what councillors can do. With a precedent like this, if a councillor wants to table a resolution calling for the rehabilitation of the events of June the 4th, 1989, will he or she be disqualified because the act constitutes unfaithfulness to the People's Republic of China? As I stated yesterday, this has unfortunately helped C.Y. Leung's cause for re-election, not the least of which he's demonstrated to Grandpa that he can deal with the independent supporters at the expense of the general welfare of Hong Kong. I also think it's time for some pro-Democrats in the legal sector to judicial review the chief executive's oath that he delivered in 2012. Hong Kong was omitted in that oath. This chief executive wants to use the law to play hardball. You can do that too.
You missed Gary's comment. There's also a comment from Gary Lamb on Facebook who says, who cares? These Pandem and Hong Kong indie BS scum need to be out. RTHK, of course, is largely a platform for those scum to spread their nonsense. Okay, some more comment from listeners. G says, interpretations are contrary to a basic policy of the Central People's Government as stated in the Joint Declaration. It is rule by law, not rule of law. And let's see, Bowen. Bowen was also inquiring about, he was concerned also about contempt of court and this issue being sub judice. We'll have a ruling from Danny.
I'm not in a position to give a ruling. Yeah. We've got Lawrence Barr, another lawyer in the panel, but we're talking here about a civil case. This is not a criminal case. This is a civil case. It's before a judge, not a jury. I mean, the test of contempt of court is a serious risk of real and substantial danger of prejudice to the fair hearing of a case, and I think we stop well short of that.
Okay. He goes on to say there's a lot of emails, and we'll get to them in the course of the next 25 minutes or so. Bowen also says today, what will be resolved by the judicial review hearing and NPCC interpretation of the Basic Law, if any, are only the legal points. They cannot resolve the political situation, which can only be effectively dealt with if the central government is willing to implement one country, two systems fully and give Hong Kong the high degree of autonomy as promised. By the way, Mr. Benjamin Yu, SC, would do well to broaden his intellectual base and take note of the way the word nation is used in other parts of the world. It worries me to hear Peter Wong say that the NPCSC will base its decision as to whether to interpret the Basic Law or not on how the public feel about the court's decision. Why does the NPCSC not react to the majority of Hong Kong's negative and angry response to the 831 constitutional reform package, for instance? This extremely heavy emphasis on the strength of public feelings at some time, but not at other times, smacks of tactics used in turbulent periods of Chinese politics in the past. That comes from Bowen.
Well, we should perhaps give Peter Wong a chance to respond to that. Peter Wong, how about the point that Bowen made? You said that the Standing Committee should consider public opinion on this oath-taking controversy. Surely, if you're consistent on that, the Standing Committee should have considered public opinion on the 831 decision on the rules on universal suffrage, which, of course, was very negative in Hong Kong.
The August 31st the ruling, I was also part of it. I was in that discussion in NBC, and we were actually responding to 1.8 million people's support of pushing that through. So that we have taken into the considerations the sentiment of the Hong Kong people. I think it has always been very consistent of that. But I think that let's come back to the question of this oath-taking issue. We have talked of so far on the technicality, on the legal technicality. We also touched on the political stance. I think another aspect which the issue have not been addressed is the cultural aspect. What these two young people, they are so ignorant and or innocent in a sense. They don't know what they have done. It really culturally touches on an old wound of a whole nation.
If they don't know what they've done and they're young and innocent, or innocent, you say, surely we believe in giving people a second chance, don't we?
No, not in a serious matters like in the legislature. I mean, you can make mistakes on your own and then rectify it on your own matter. But this really has profound effect on not only just the public in Hong Kong. It touches on the whole the ethnic, the Chinese sentiment.
Would you say they should be allowed?
A cultural matter, when we are talking of the legal system, legal framework, laws we are making that really to serve the people, how the people feels. They're comfortable about it.
So we could have a by-election and they could stand again?
I don't know. That would be another technical matter. But the thing is, at the moment, what they have done, they don't know what they have done. It's really, it antagonizes every Chinese and also people or friends of Chinese as well.
Okay, we're joined by another guest, Richard Ip. Richard Ip is barrister and member of the Progressive Lawyers Group. Good morning, Mr. Ip. Thank you for joining us.
Good morning.
So what do you make of Peter Wong's comments just now?
Well, I think the prime focus should be what is one country, two system with a high degree of autonomy. Right? The interference or the threat of interpretation made by of NPCSC is obviously an interference with Hong Kong's internal affairs, and most particularly the British independence. So I think this is a bad sign for the one country, two system principle and the high degree of autonomy in Hong Kong. Imagine what the pressure that the court would face, because any adverse decision, if it gives any adverse decision, it's foreseeable that it will face a high of pressure from all sides.
But there hasn't been any standing committee interpretation. We can't be sure that there will be one.
Yes, there hasn't been, but the threat is like a hanging dagger over the court. If you were the judge, that's definitely a factor that you would have to consider, because the court would not want to risk another interpretation of the NPCSC overruling its decision. But
all courts have many courts have there's another authority above them that's not seen as a dagger. The court of first instance, there are appeal courts and so on. The court of first instance doesn't, feel constrained or anything by the possibility of appeal. It's just what they do, and in the same way, there's the possibility of an interpretation by the NPC Standing Committee. It's part of the process. It's been part of the process in the past. It's mandated under the Basic Law. It's no surprise to anyone or anything particularly sinister.
Yes, you're right that if theoretically the court needs not to consider it, okay, and it's just another case in the court, correctly. But judges are human beings, and they will be affected. And think about it, from the judge's perspective, if you make a ruling that's directly contradictory to the NPCSC's ruling, that would create quite a mess that he would like to prevent, to maintain equity of the judiciary in Hong Kong.
Well, I'm very surprised by this saying, because my belief of the judges, their rulings are ruled on their own conscience and not being affected by the other elements, like what is suggested. Whether other people overrule because of the system, that is the secondary consideration of any judges. It's surprising, come out of a learned friends to see the framework of a judge.
Do you think, Peter Wong, you think judges can operate in a box, oblivious to what's happening around them?
No, their professional training is to be truthful to themselves. If they believe that their judgments are right, I think that is what they should make their ruling on, instead of it will be thrown away or being put aside tomorrow.
All right.
That is, as a JP, I have sit on the judge panel in the past. We have that honor before the handover, before 1997. The JPs can sit on the civil courts if the magistrates are not there. So I think judges, that is a minimum professional qualification all judges have. So all these suggestions of putting pressures on judges is really twisting the professional fundamentals of judges.
Okay, some more comments. Pete says, do you really think that Youngspiration 2 would be allowed to stand again if there is a new election? And Drake, I think he's quoting Michael Tin on commercial radio this morning, who says they have finally decided to interpret the law to kill both the oath-taking and the candidacy issues, like Edward Lung and et al., in one stone. It acts as a warning that whatever the judicial system is, there exists some vastly important major principles that can't be compromised. Anthony says, professionals, were Lung and Yao elected by the voters to get into LegCo to fight for the interests of them or to mess up the oath and end at the entrance? Anthony Eden and David Cameron stepped down even though they were elected by their voters. Sorry, they have no votes from their Brits. It's the party. That's Anthony's take. Neil says, what's the difference between Scottish nationalists campaigning for ultimately legal independence and Youngspiration? Anthony says, hi Danny, as a law PhD, can you tell me why the NPC interpretation is detrimental to the rule of law, while such interpretation in the right of abode years ago was well received by the general public? People welcome something detrimental to the rule of law.
Well, I'm here as a host. I didn't say that it's detrimental to the rule of law. I think we'll pass that one back to Richard Ip.
Can I throw another question at you then, which I think you may also be able to clarify. This is from Andy, who says, can the NPCSC only interpret the basic law of Hong Kong, or can it also interpret Hong Kong laws enacted in Hong Kong? It's difficult to see how one can interpret Article 104 of the basic law because the meaning is already very clear.
Well, that is a legal matter, and Lawrence Marr, perhaps we bring you back in on this. Andy's raised a very important point there. I mean, the Standing Committee's power is quite clear. The Standing Committee's power is only to interpret the Basic Law. It's not to interpret other Hong Kong laws. And large elements of this case about whether these two have disqualified themselves involve Hong Kong law rather than the Basic Law. They involve the Open Declaration Ordinance, and any Standing Committee interpretation would be essentially reaching beyond the Basic Law through the Basic Law to Hong Kong law, wouldn't it?
Well, I mean, it's not that hard to understand. I thought that the case touches on both provisions, both Section 21 of the Open Declaration Ordinance as well as Section 104, which requires
Article 104 of the Basic Law.
Article 104. Yes. Then you understand that requires the public officers, many of them the chief executive and principal officials, as well as legislative council or judges, to make an oath and to swear allegiance to the country. Now that would
surely the point is the Standing Committee can interpret the Basic Law part. They shouldn't be interpreting the ordinary, and this is the point Andy was making, they shouldn't be interpreting the ordinary Hong Kong law part, and the ordinary Hong Kong law should be for the courts alone.
Sure, that's true.
But in practical terms, what you quite possibly seeing is Standing Committee interpreting the Basic Law in a way that then affects ordinary Hong Kong law. After all, the Basic Law is higher.
That really does so, because Hong Kong law has to be constitutional. If it has to be a rule that Article 104's oath-taking can only be done once, I think it would have the effect of interpreting other local Hong Kong laws, yes.
Richard, would you like to come back on this point that our listener raised, that Standing Committee essentially can be reaching beyond interpreting just the Basic Law to affecting other Hong Kong laws as well?
Yes, I think that would be the effect of such an interpretation. They would be sort of interfering with the affairs of Hong Kong directly, and that undermines the high degree of the autonomy in Hong Kong. It's theoretically it's permissible. I think there's an argument for them to do so, but whether they should do so is a political matter. And ultimately, it goes back to why are we having this one country, two system? Why don't we just have one country, one system?
How about the point our earlier listener raised also? You've had previous Standing Committee interpretations of the Basic Law, and there were dire predictions about the consequences at the time, but our legal system did survive, and almost 20 years later, people do still trust the courts. So perhaps we overreact when we talk about the possible consequences of Standing Committee interpretations.
This interpretation, if it came true, it would further undermine the people's confidence, or at least the international community's confidence, in the independence of the Hong Kong judiciary.
One more. This is comment from Peter in an email, who says it's pretty clear that the Hong Kong government and almost certainly the PRC government just want to remove the Youngspiration members from LegCo. It's also clear the way the people discuss NPC interpretations, that though technically they may be legal decisions, they are in practice almost entirely political decisions, the general outcome of which is known in advance. So we have a political decision overriding the legal decision of the Hong Kong courts. This is highly damaging of the legal system in Hong Kong, as the Chief Justice has already implied. Those who push for an interpretation now or threaten to seek one if the court doesn't decide in the right way are obviously more interested in making political gestures than protecting the fundamental values of the Hong Kong system. That comes from Peter. Peter Wong. That's true, isn't it? You and the NPC Standing Committee conceivably are just trying to use. You don't like political developments that are going on in Hong Kong, and you're trying to use the law to stamp them out.
No, definitely not. I think what these two young people are doing is that touches the bottom line of the constitutional right of the sovereign state. What they act in any legislatures or Congress is amount to an act of treason. Can other government tolerate it?
Well, yes.
I think that is was also raised. The technicality.
Are you saying
the context?
No, you can't. You can say
that is the bottom line. You know,
you can't appeal to other jurisdictions, because in other places you can. You can. There are independence movements, as you know, in the United Kingdom or other places.
No, not in when any congressman, councilman, when they make an oath, the similar act by the other nations would be perceived as an act of treason. You are promoting independence of the state when you want to really participate in that, institution. So I think that We jump around this morning on a lot of the technicality and missing the contents. What they have done is really touching the bottom line.
You say they committed treason, Peter Wong. We have laws against treason in Hong Kong. Nobody suggested prosecuting them for treason.
But I think this is amount to that. That's why we hope to see what the court comes up with.
The bottom line is that you don't like what's happening politically, and you are trying to use the law. You're trying to use legal means to address what is really a political problem, what is really a political issue.
And also a cultural one. It's cultural,
maybe.
Political, and legal.
Yeah, I can understand why you say it's a cultural problem. I can understand why you say it's a political problem. But by manipulating legal means to address that, you're undermining the whole system.
What manipulating? It is not manipulating. It is embossed and written down there. Now, when people separate the basic law and the Hong Kong law, I think that is also just rhetoric.
Well, by for example, invoking public opinion. That's public opinion shouldn't be a matter. Shouldn't affect the law, as you yourself have said.
I think the law,
as you yourself have said when you were acting as a judge, you have to look at the case on its own merits, and you have to look at the law, and you have to work from that. And, you're not worried by the threat of a higher court. You're not worried by the threat of public opinion.
Yeah, the thing is that if we had any legal system is really to reflect. To protect the rights of the people, and the rights of the people is expressed by the sentiments. I think that is just as a layman, not as many of the learned friends I think that is how an ordinary people like us, like to express and hope that the law would give them judgment.
Well, that's the difference. Well, that's the difference
Hong
between
Kong law and also the NPC is part of the China.
Yeah.
The one country, two system. A legal framework. You cannot rule out the NPC as not part of the legal framework of Hong Kong.
Isn't that rule by law, not rule of law?
Well, I think it both by and of law. In Hong Kong, one country, two system. This new thing is now being studied by the world at large as well. So I think that we can play along with the technicality and the rhetoric, but I think it doesn't change the content. What these two young men has done in a solemn legislative chamber, in expression of really an act of treason,
But you talk about a solemn chamber. It's not a church. It's a place for argument. It's a place for political debate. It's a place for discussion.
Well, but making a vow and an oath. As you. Making a commitment, even in a marriage wedlock, or making any vow, that is a very solemn thing. Before you talk of, you cannot really say whatever you like at that particular. It is a commitment to an undertaking in future. And I think if people doesn't even respect the meaning of an oath and a vow taking, I think they may not be really entitled to what they want to really do for the public in future. Okay,
just to wrap up with some more comments from listeners. Tom says, the rule of law in China is based on the assumption of the state's ultimate control and order of society, but not about justice as it does in the West, as well as the Hong Kong supposedly independent and robust common law-based legal system. Dr. Ho talked about order and control by the central government as prescribed by Han Fei-Tse's legalism. The case has proven clearly that there is only one country, one system, and there is no separation of the executive, judiciary and legislative branches. Joe Average says, how can we have independence from China when Hong Kong is building all these thousands of flats for China? They're not for Hong Kong residents because they're over $3 million. If Hong Kong wants flats for Hong Kong, they need to be $1.5 million. Adeline says there are clear differences in what law and legal system is for one for the justice for everyone, and one is for maintains power and control by the sovereign. Pete says, with a court of appeal, you don't know what the outcome will be. With an interpretation, you do. And H finally says, Dear Backchat, thank you for bringing interesting topics of discussion. Would it be possible to announce what will be discussed the following day? Thank you. That comes from H. H, we don't know until, most of the time we don't know until after the programme what we're going to be talking about the next day. So thank you very much indeed for that comment. Anyway, and thank you to all our guests, to Peter Wong, NPC Delegate, Barrister Lawrence Ma and Richard Yip. Thank you very much indeed.